This is an emergency episode. If you're a father who hasn't filed for court yet, you need to listen very carefully to what I'm about to tell you. And if you have an active case, what I'm about to explain could fundamentally change your strategy. The UK Parliament is currently considering the Children's Wellbeing and Schools Bill 2025. Buried in Part 1, Clause 54 of this bill is something that will devastate fathers' rights for a generation. They're removing the only legal protections fathers had in family court, and most fathers have no idea it's happening. Today I'm going to explain what this bill does, why it matters, when it's happening, and what you need to do right now before it's too late. Let's get into it. What is the presumption of parental involvement? First, let me explain what we're about to lose. In 2014, Parliament amended the Children's Act 1989. They added section 1 to A, which says, a court is to presume, unless the contrary is shown, that involvement of each parent in the life of the child will further the child's welfare. This was huge for fathers. For the first time, there was a statutory presumption written in law that children benefit from having both parents involved. Before 2014, family courts operated on pure judicial discretion, and in practice, that meant mother gets child, father gets scraps. The 2014 amendment was meant to fix this. It was meant to say, courts, you can't just default to giving mother everything. You have to presume both parents matter. When you file for contact after 2014, your solicitor could say to the judge, Your Honour, Section 1(2)(a) creates a statutory presumption that my client's involvement furthers the child's welfare. The burden is on the respondent to show why that presumption should be displaced. It shifted the burden slightly, not much. Court still favoured mothers heavily, but it was something. It meant mother solicitor had to actually argue why fathers shouldn't have contact, rather than the father having to argue why he should. Did the presumption work? Partially. Research from 2014 to 2019 showed a small but measurable increase in shared care arrangements, though still rare. More overnight contact for fathers, courts at least considering the father's role. It wasn't revolutionary. Status quo bias still remained. Mothers still won most cases, but it was better than nothing. It was the only statutory recognition that fathers matter, and now they're taking it away. What the bill does. Here's what the Children's Wellbeing and Schools Bill 2025 actually says. Part 1, Clause 54 is titled Parental Involvement, Consequential Amendments. It sounds technical and boring. That's intentional. They don't want you to pay attention, but here's what it does. It repeals Section 1(2)(a) and Section 1(2)(b) of the Children's Act 1989. That's it. Those sections are deleted, gone. Now, Section 1(2)(b) defined what involvement means. Involvement means involvement of some kind, either direct or indirect, but not any particular division of a child's time. This clarified that involvement didn't automatically mean 50-50 custody, but it did mean something meaningful in your child's life. Also deleted. After this bill passes, we return to pre-2014 law. No presumption that both parents should be involved. No statutory recognition that fathers matter. Pure judicial discretion, and judicial discretion, as we've seen for decades, means mother gets child. Father gets supervised contact once per month if he's lucky. The government says this is about simplifying family law and giving judges more flexibility. Nonsense. This is about removing the only constraint on maternal preference bias. The real reason is pressure from domestic abuse charities. You argued the presumption was being used by abusive fathers to get contact. But never mind that. The presumption could be rebutted with evidence of abuse. Courts already had power to deny contact in abuse cases. The vast majority of fathers are not abusive. They're throwing out the baby with the bathwater, removing all protection for fathers because of a tiny minority that might abuse it. So when this happens, February 2026, the bill will be introduced to Parliament and is currently in the committee stage. Government backed and likely to pass. Expected timeline. The committee stage is in February to March 2026. The third reading is going to be in April to May 2026. House of Lords, May to July 2026. Royal Assent, July to August 2026, comes into force likely in 2 to 3 months after Royal Assent. The realistic date it becomes law, around about October to November 2026. Once the bill receives Royal Assent and comes into force, Section 1(2)(a) will be deleted. Any case filed after that date will not have the presumption. Any case already in progress will continue under the old law, probably. It isn't 100% clear yet. This means you have approximately 8 to 10 months before this protection disappears. So what this means for fathers. Let's be brutally honest about the impact. Before October 2026, with a presumption, your solicitor files your C100 application. In the position statement, they write, pursuant to Section 1(2)(a) of the Children's Act 1989, the court is to presume that the involvement of both parents furthers your child's welfare. And they'll say, my client seeks shared care of regular contact, and the burden is on the respondent to demonstrate why this presumption should be displaced. The judge must consider this presumption. They can override it, but they have to address it. Mother solicitor has to argue, here's why the father's involvement does not further welfare. But after October 26, without this presumption, your solicitor files your C100 application and they cannot reference the Section 1(2)(a) because it does not exist anymore. Instead, they write, my client seeks contact with his child, and that's it. No presumption, no burden shift. The judge considers mother's current care arrangements, the status quo, and your request for contact represents disruption. Guess which one wins? With the presumption, courts start from both parents should be involved unless. Mother has to prove why not. The father has statutory backing for his position. But without the presumption, courts start from what's best for the child, and in practice that means what's the current arrangement? It's the mother. Father has to prove why change is needed, and status quo bias dominates completely. The expected impact and outcomes. Based on pre-2014 data, we can expect, in terms of shared care orders, the current rate with the presumption, 15 to 20% of cases. The expected rate without the presumption, 5 to 10% of cases. The net loss, 50 to 70% reduction in terms of overnight contact. The current rate, 40 to 50% of fathers get some overnight. The expected rate, 25 to 35% of fathers get overnight. The net loss, 30 to 40% reduction. In terms of no contact at all, the current rate, 15 to 20% of fathers get no contact. The expected rate, 25 to 35% of fathers get no contact. A net increase of 50 to 75% more fathers get completely cut off. These are estimates, but based on solid pre-2024 data. The removal of this presumption will devastate father-child relationships. What you need to do now. If you're watching this and haven't filed for contact yet, here's your action plan. Option 1, file before October 2026 is recommended if possible. Why? Your case will be governed by the law at the time of ruling. Section 1(2)(a) will likely still apply to your case, even if it's repealed during your proceedings, because you started with the presumption. Timeline. File C100 application by September 2026 at latest. This gives you a buffer in case the bill passes early. Your case will be grandfathered under old law. How? Complete the MIAM, which is the Mediation, Information and Assessment Meeting, now. Get your C100 form from gov.uk, gather evidence, file with the court and pay your £215 fee. What do you need? Evidence of your relationship with your child, attempts at contact you've made, why contact matters to your child's welfare, your ability to care for your child, and anything showing the mother has blocked contact. Your solicitor will reference Section 1(2)(a) throughout your case. This matters even if proceedings take years. The law at filing determines presumptions. Option 2. If you can't file before October 2026, adapt your strategy. If you literally cannot file before the deadline, maybe you're still in MIAM. Maybe the mother hasn't filed yet. Maybe you need more evidence, then you need a different approach. Without Section 1(2)(a), you need to build an overwhelming case based on research of child development and father involvement, expert evidence, child psychologists supporting contact, documentary evidence of your parenting capability, evidence of the mother's obstruction harms your child, case law from European Court of Human Rights on Article 8, right to family life. This is harder, much harder, but not impossible. The critical point, while Section 1(2)(a) exists, use it. Reference it in every document, position statements, skeleton arguments, witness statements, responses to CAFCAS. Make it central to your case. After it's repealed, you can't suddenly add it back. But if your case started with it, courts should continue applying it. This is untested law. We don't know for certain how courts will handle cases that span the repeal. but starting with the presumption is better than never having it. Make your C100 filing date matter. File while you still have statutory protection. If you're already in proceedings now, February 2026, your case should continue under current law, but monitor this. If court tries to apply new law for your old case, object. Argue law at filing governs. Political action you can take. Here's what you can do to stop this or at least make some noise about it. 1. Contact your MP. Write to your MP, find them at members.parliament.uk, and the template will be along the lines of, Dear MP name, I am writing regarding the Children's Wellbeing and Schools Bill 2025, specifically Part 1, Clause 54. This clause repeals Section 12A of the Children's Act 1989, which created a presumption that involvement of both parents furthers a child's welfare. I am a father, or I know fathers who rely on this protection in family court. Removing it will return us to pre-24 maternal preference bias, making it harder for children to maintain relationships with fathers, increase the number of children growing up without fathers. I urge you to vote against Clause 54 or seek its removal from the bill. Raise this issue in parliamentary debate. Request impact assessment of how this affects fathers. Research shows children benefit from both parents' involvement. This undermines that principle. Yours sincerely, then your name, your address, your postcode. Option number 2, sign petitions. Current petitions. Check these websites. Parliament Petitions website, petition.parliament.uk, change.org petitions, campaign group petitions, Families Need Fathers, parity. If a petition gets 100,000 signatures, Parliament must debate it. Or option number 3, submit to committee. Whilst the bill is in committee stage, public can submit written evidence, check the Parliament website for submission deadlines, share your experience, anonymised, explain impact of father-child relationships. Option 4, join campaign groups. These organisations are fighting for this. Families Need Fathers, website fnf.org.uk, leading the campaign against Clause 54, organising lobbying efforts, coordinating father responses, or Parity, website parity.uk, focused on sharing parenting law, actively opposing removal of presumption, research and lobbying, Both Parents Matter, direct action and awareness campaigns, social media campaigns, media engagement, join, donate, participate. Option number 5, media attention. If you can speak publicly without identifying your case, contact local media about impact, write to national newspapers, letters to the editor, social media campaign, #save section 12A, share this video. More noise equals more pressure on MPs equals a better chance of stopping this. Option 6, legal challenge, a long shot. After the bill passes, there may be grounds for judicial review. Breach of Article 8 ECHR, right to family life, discriminatory effect on fathers, insufficient consultation. This would be extremely expensive and difficult, but campaign groups must pursue it. If it passes, how to adapt? Realistically, this will probably pass. Government has majority, it's in a huge bill about schools, and most MPs won't even notice Clause 54. So how do you adapt? 1. Evidence becomes everything. Without statutory presumption, you need overwhelming evidence. Document everything. Every contact, every gift sent, every message to mother, every interaction with your child if you have any. Gather professional evidence. School records showing your involvement. Medical records showing you attend appointments. Witnesses to your parenting. Photos and videos with your child. Consider expert reports. Child psychologists on benefits of father involvement. Attachment specialists. Independent social worker assessment. Or 2, focus on attachment research. Instead of relying on statutory presumption, rely on research. Attachment theory, Bowlby, Ainsworth, research on father absence outcomes, developmental psychology and two-parent benefits, specific research on your child's age group. Build legal argument on established research rather than deleted statute. 3, challenge status quo directly. Without Section 12A, courts will fall back on status quo even harder. Your strategy. Argue status quo wasn't created by mother's obstruction. Show your child's stability with mother isn't actually stable. Demonstrate harm from limited father contact. Present an alternative. Stability comes from both parents. Option 4, use international law. Section 128 is gone, but Article 8 ECHR, Right to Family Life, still exists. UN Convention on Rights of the Child, Article 9, your child's right to both parents, case law from Court of Human Rights. These don't create presumption, but support the principle. Or 5, the long game. This is a setback, not the end. Continue campaigning for shared parenting law like Australia, Belgium, Sweden, reintroduction of presumption, statutory recognition of father's importance. This fight doesn't end with clause 54. And in closing, I know this is depressing. Losing section 128 is a massive blow, but here's what I need you to understand. The law was always stacked against fathers. Section 128 didn't fix that, it just gave us a tiny statutory foothold. Now they're removing that foothold, but the climb doesn't stop. If you haven't filed yet, file before this passes and get grandfathered under the old law. If you can't file yet, adapt. Evidence, research, expert reports, international law, build an overwhelming case. And politically, make noise, contact MPs, sign petitions, join campaign groups. Don't let this happen silently. Most importantly, don't give up. They want you to give up. That's why they're making it so hard. That's why they remove the protections. That's why they create impossible barriers. But your children need you, and you need to fight for them. Section 128 is dying, but the principle that children need both parents, that's not up for debate. It's just reality. So we fight with the tools we have left. If this video has helped, share it with every father you know. They need to see this before it's too late. And subscribe. We're going to keep fighting this system together, and I'll see you in the next one.